You know, we've all had disagreements with neighbors, right? But today, we're jumping into a real classic, a homeowner going head-to-head with their homeowners association, or HOA. A simple project spirals into a legal battle, and believe it or not, it all came down to a measly 4 inches. Okay, let's get into it.
You'd think so, wouldn't you? You buy a house, it's your castle, you get to make the rules. But what happens when there's a community rule book, sometimes a massive one, that says something completely different? That's the exact question at the very heart of this story.
So, let's meet our homeowner, Debbie Westerman. Back in October 2017, she buys this great townhome in Arizona. Her plan was pretty simple: build a nice courtyard wall for a bit of privacy. She hired a contractor, got the plans ready, and sent them off for approval. And that's where things got complicated. And things escalated fast. I mean, really fast. What started as just a standard request in October gets flat out denied by the HOA in early January. Well, Debbie wasn't taking no for an answer. Just 3 weeks later, she files a formal petition against them. And by April, this whole thing over a simple wall is heading to a formal hearing with a judge.
So what was the big holdup? What was this huge fight all about? You're going to love this. It all boiled down to the cinder blocks. Her contractor recommended using a standard 8-inch wide block, said it was stronger, cheaper, the whole deal. But the community rulebook was crystal clear. Walls had to be built with a 4-inch wide block. That's it, a 4-inch difference. That's what this entire legal fight was about.
Now, to be fair, Debbie wasn't just trying to break the rules for no reason. She really believed she had a good case for why her way was better, and she was ready to argue that the 8-inch block wasn't just okay. It was actually the superior choice. She came to that hearing with 4 main arguments. First up, strength. Her subcontractor got up and testified that using the smaller 4-inch blocks literally doubles the chance of the wall failing. Second, cost. She talked to 3 different contractors, and they all said the bigger blocks would be cheaper. Third, looks. She argued that once the wall was built and finished, you wouldn't even be able to tell the difference. And finally, she pointed the finger at the HOA, showing photos of other walls in the neighborhood that she claimed didn't follow the rules either.
Okay, so what did the HOA have to say about all this? Well, from their perspective, this wasn't about being difficult. They saw themselves as the guardians of the community's unique architectural vision, a vision that was set in stone long before this fight ever started.
The HOA board president basically laid it all out. He said the rules were there for architectural continuity, to make sure everything conformed to the original Beadle design. Beadle was the original designer, you see. So for the HOA, this wasn't just about one person's wall, it was about protecting the look and feel of the entire neighborhood.
And here's the kicker. This wasn't some new rule they just pulled out of thin air. The HOA brought up a very important number, 29. That's how many other homeowners had already built their walls following the exact same 4-inch rule. So making an exception for Debbie wouldn't just be breaking a rule. It would be totally unfair to all those neighbors who had already complied.
All right, so you've got 2 very different arguments here. The homeowner is all about the practical stuff, strength, cost. The HOA is focused on principle, consistency, design integrity. Now it's time for the hearing, where the judge has to sift through all this and decide who's right.
And let me tell you, the HOA came ready for a fight. For every single claim Debbie made, they had an answer. She says her wall is stronger. They slide over an expert engineering report. She says her wall is cheaper. They produce a recent quote showing a compliant wall was perfectly affordable. And those photos of other non-compliant walls? The HOA calmly explained those were built way back before 1980, before the current rules were even in place.
But then came the real knockout punch. That expert report, it was from the National Concrete Masonry Association, a totally impartial source. And it said, point blank, that the 4-inch blocks could be considered structurally equivalent to the 8-inch ones. Just like that, the homeowner's #1 argument that her wall was stronger and safer was completely dismantled. So, after all the testimony, the contractor opinions, the engineering reports, the judge had to make a call. You had the homeowner with a case built on what seemed like common sense, and the HOA with a case built on rules, precedent, and expert testimony. So who won?
The verdict came down, and it was decisive. The judge ruled in favor of the Homeowners Association. Debbie Westerman's request to use the 8-inch block was officially and legally denied. The big question is, why?
Well, the judge broke down the reasoning into 4 pretty simple steps. Step 1, the HOA's rules were legit, and they absolutely had the authority to enforce them. Step 2,
Their goal of preserving that Beadle design was perfectly reasonable. Step 3, the homeowner just couldn't prove that the 4-inch blocks were actually worse in any meaningful way. And finally, Step 4, the judge agreed that an 8-inch wall would look noticeably different and mess with the community's uniform appearance.
This whole story is a huge reminder that when you buy a home in a community with an HOA, you're not just buying a house, you're buying into their rule book. Something that seems like a tiny detail, like the width of a cinder block, can be a really big deal. So it leaves you with one final question to think about. Before you build or buy, do you really know what's in your community rulebook?